Today I want to talk about the successes of the False Claims Act. That's a law that traces way back to the Civil War. Passed by Congress then and signed by President Lincoln in 1863, the False Claims Act created incentives for individuals to curb a rash of fraud against the government, at that time mostly coming from military contractors. As we all know, the key to the False Claims Act's success is that it allows whistleblowers to sue fraudsters on behalf of the federal government by standing in the shoes of the United States government. In 1986, I passed amendments to make the False Claims Act much more effective. Since the 1986 amendments to the False Claims Act, cases have recovered more than $64 billion for the taxpayers. I'm told that it is more than enough to buy every member of the U.S. Armed Forces a new Ford Bronco, with enough left over to purchase an additional 6 dozen F-35s. Obviously, this makes it one of the most effective tools at the disposal of the federal government's Department of Justice for prosecuting and deterring fraud while protecting taxpayer dollars. Just in the last year, the Department of Justice reported that it recovered more than $2 billion in fraud. Making sure the False Claims Act remains strong requires strong congressional oversight. Too often, judges and administration officials of both political parties misinterpret the words and spirit of this law and do great harm to the government's ability to hold fraudsters accountable. In just the last few years, courts have read into the law a more stringent materiality standard than the text of the statute provides, and the Department of Justice has moved to dismiss dozens of cases under the incorrect interpretation that they have unfettered discretion to do just that. This last Congress, I sent 2 letters to Attorney General Barr raising concerns about the department's use of its dismissal authority. As the author of the amendments that empowered whistleblowers, I have long held that if a case lacks merit, the Justice Department is within its rights to seek its dismissal. The False Claims Act is not an avenue for parasitic or frivolous lawsuits. However, the only way the public is reassured that a case lacks merit and ought to be dismissed is if the Department of Justice presents that evidence in a court of law. Doing so will provide transparency and reassure whistleblowers across the country that the government is not arbitrarily dismissing their claims. So simply put, if there are serious allegations of fraud against the government, the Attorney General should have to state legitimate reasons for deciding not to pursue them in the courts. That's common sense. Today, most of the recoveries from fraud come from the companies in the healthcare industry, including drug and medical device manufacturers, managed care providers, hospitals, pharmacies, and laboratories. As the country continues to battle the global pandemic, the False Claims Act has never been more important than it is right now. The massive increases in government spending to address the COVID-19 crisis have created new opportunities for fraudsters trying to cheat the government and steal the people's money. And as history has shown all of us, fraudsters thrive during times of crises and large-scale government spending. Several False Claims Act cases are already starting to pile up in relation to the COVID-19 pandemic. Earlier this year, the Department of Justice reported its first civil settlement resolving allegations of fraud against the Paycheck Protection Program of the CARES Act. I hope that's a sign of things to come. That's why it is important that Congress, the Department of Justice, and whistleblowers remain very vigilant. We must ensure that the trillions of dollars spent to combat this pandemic do not go to enriching fraudsters who seek to take advantage of these challenging times. Congress depends on the American public to be vigilant and to speak up if they see something happening that they know is terribly wrong. Those who do choose to step forward and report violations in accordance with our federal laws deserve federal whistleblower protections and the backing of the federal government when they seek to expose fraud and to protect taxpayer dollars.